Simplified Leonen Cases 2015. Trigger your mind. A demurred evidence is defined as an objection by one of the parties in an action, to the effect that the evidence which his adversary produced is insufficient in point of law, whether true or not, to make out a case or sustain the issue. We have also held that a demurred evidence authorizes a judgment on the merits of the case without the defendant having to submit evidence on his part, as he would ordinarily have to do, if plaintiff's evidence shows that he is not entitled to the relief sought. A petition for review on certiorari under Rule 45 pertains to questions of law and not to factual issues. A question of law which this court may pass upon must not involve an examination of the probative value of the evidence presented by the litigants. As a rule, the jurisdiction of this court is limited to review of errors of law allegedly committed by the appellate court. It is not bound to analyze and weigh all over again the evidence already considered in the proceedings below. On June 23, 2003, Republic Act No. 9211, Tobacco Regulation Act, amended Article 94. F. Republic Act No. 7394, the Consumer Act of the Philippines, by providing in its Section 13 as follows. Section 13. Warnings on cigarette packages. Under this Act, A. All packages in which tobacco products are provided to consumers withdrawn from the manufacturing facility of all manufacturers are imported into the Philippines intended for sale to the market, starting the 1st of January 2004, shall be printed, in either English or Filipino, on a rotating basis or separately and simultaneously, the following health warnings. Government warning: cigarette smoking is dangerous to your health. Government warning: cigarettes are addictive. Government warning: tobacco smoke can harm your children. Or government warning: smoking kills. Art. 94. Labeling requirements of cigarettes. All cigarettes for sale or distribution within the country shall be contained in a package which shall bear the following statement or its equivalent in Filipino. Warning: cigarette smoking is dangerous to your health. Such statement shall be located in conspicuous place on every cigarette package and shall appear in conspicuous and legible type in contrast by typography, layout or color with other printed matter on the package. Any advertisement of cigarettes shall contain the name warning as indicated in the label. Rape under Article 266A of the Revised Penal Code, RPC. AAA is a credible witness. Appellant's denial and sweetheart theory unavailing as against AAA's testimony. Newly ruptured hymen on the part of the victim is not an element of rape, so too is ejaculation on the part of perpetrator not an essential ingredient of the crime. Comprehensive Agrarian Reform Program, CARP. Section 1. Primary and exclusive original and appellate jurisdiction. The board shall have primary and exclusive jurisdiction, both original and appellate, to determine and adjudicate all agrarian disputes involving the implementation of the Comprehensive Agrarian Reform Program, CARP, under Republic Act No. 6657, Executive Order Nos. 228 and 129A, Republic Act No. 3844 as amended by Republic Act No. 6389, Presidential Decree No. 27 and other agrarian laws and their implementing rules and regulations. Specifically, such jurisdiction shall include but not be limited to cases involving the following. C. The annulment or cancellation of lease contracts or deeds of sale or their amendments involving lands under the administration and disposition of the DAR or LBP. F. Those involving the issuance, correction and cancellation of certificates of land ownership award, CLOAs, and emancipation, patents, EPs which are registered with the Land Registration Authority. Agrarian dispute. Section 3D of the CARL defines an agrarian dispute as XXX, any controversy relating to tenurial arrangements, whether leasehold, tenancy, stewardship, or otherwise, over lands devoted to agriculture, including disputes concerning farm workers' associations or representation of persons in negotiating, fixing, maintaining, changing or seeking to arrange terms or conditions of such tenurial arrangements. Allegations in the complaints. In order for the DARAB and PARAD to exercise jurisdiction over such controversies, sufficient allegations establishing the existence of an agrarian dispute must be made in the complaint following the rule that the jurisdiction of a tribunal, including a quasi-judicial officer or government agency, over the nature and subject matter of a petition or complaint is determined by the material allegations therein and the character of the relief prayed for, irrespective of whether the petitioner or complainant is entitled to any or all such reliefs. Question on vitiation of consent. Settled as the rule that this court is not a trier of facts. In that regard, the court notes that the CA failed to pass upon the question on whether fraud Undue influence and mistake occasioned the procurement by respondent to the titles to the properties and whether there was indeed a violation of the CARL. As there were none, the court finds it necessary to remand this case to the CA for the proper review of the substantive issues as raised by the parties concerning the legality of the transfer of the properties to the respondent. Note these allegations plainly show that the petitioners are invoking their rights as beneficiaries of the CARL. That they consider the conveyance of their properties as having been made in violation of the terms and conditions of the CARL. And that all of the transfers should be nullified because they were procured through fraud, undue influence and mistake. All these constitute an agrarian dispute in the context of a controversy relating to terms and conditions of transfer of ownership from landowner to agrarian reform beneficiaries. This is because the main contention of the parties was clearly couched on the alleged denial by the respondent of their established rights as beneficiaries over the subject properties under agrarian reform laws. Sec. 3 C. ABRA number 6657, the Comprehensive Agrarian Reform Act, provides that C. Agricultural land refers to land devoted to agricultural activity as defined in this act and not classified as mineral, forest, residential, commercial or industrial land. Also, Sec. 3b of said law defines agricultural activity as the cultivation of the soil, planting of crops, growing of fruit trees, raising of livestock, poultry or fish, including the harvesting of such farm products and other farm activities and practices performed by a farmer in conjunction with such farming operations done by person whether natural or juridical. Sec. 22. Qualified beneficiaries. The lands covered by the CARP shall be distributed as much as possible to landless residents of the same barangay, or in the absence thereof, landless residents of the same municipality in the following order of priority: agricultural lessees and share tenants. B. Regular farm workers. C. Seasonal farm workers. D. Other farm workers. E. Actual tillers or occupants of public lands. F. Collectives or cooperatives of the above beneficiaries, and G. Others directly working on the land. The principle of unjust enrichment has two conditions. First, a person must have been benefited without a real or valid basis or justification. Second, the benefit was derived at another person's expense or damage. Warranty against the hidden defects. Under the Civil Code, the vendor shall be answerable for warranty against hidden defects on the thing sold under the following circumstances. Art. 1561. The vendor shall be responsible for warranty against the hidden defects which the thing sold may have, should they render it unfit for the use for which it is intended, or should they diminish its fitness for such use to such an extent that, had the vendor been aware thereof, he would not have acquired it or would have given a lower price for it. But said vendor shall not be answerable for patent defects or those which may be visible, or for those which are not visible if the vendee is an expert who, by reason of this trade or profession, should have known them. Emphasis applied. Art. 1566. The vendor is responsible to the vendee for any hidden faults or defects in the thing sold, even though he was not aware thereof. This provision shall not apply if the contrary has been stipulated and the vendor was not aware of the hidden faults or defects in the thing sold. For the implied warranty against hidden defects to be applicable, the following conditions must be met. A. Defect is important or serious. I. The thing sold is unfit for the use which it is intended. E. Diminishes its fitness for such use or to such an extent that the buyer would not have acquired it had he been aware thereof. B. Defect is hidden. C. Defect exists at the time of the sale. D. Buyer gives notice of the defect to the seller within reasonable time. The concept of res ipsa loquitur has been explained in this wise. While negligence is not ordinarily inferred or presumed, and while the mere happening of an accident or injury will not generally give rise to an inference or presumption that it was due to negligence on defendant's part, under the doctrine of res ipsa loquitur, which means, literally, the thing or transaction speaks for itself, or in one jurisdiction, that the thing or instrumentality speaks for itself, the facts or circumstances accompanying an injury may be such as to raise a presumption, or at least permit an inference of negligence on the part of the defendant, or some other person who is charged with negligence. As to the petitioner's prayer to make GSIS jointly and severally liable with La Paz, the court finds that there is no legal basis to juridically bind GSIS because it was never a party in the contracts between La Paz and the petitioners. The housing loan agreements that the petitioners entered into with GSIS were separate and distinct from the purchase contracts they executed with La Paz. GSIS merely agreed to pay the purchase price of the housing unit that each petitioner purchased from La Paz. It was merely the lender, not the developer. Article 2219. Moral damages may be recovered in the following and analogous cases. 1. A criminal offense resulting in physical injuries. 2. Quasi-delicts causing physical injuries. 3. Seduction, abduction, rape or other lascivious acts. 4. Adultery or concubinage. 5. Illegal or arbitrary detention or arrest. 6. Illegal search. 7. Libel, slander or any other form of defamation. 8. Malicious prosecution. 9. Acts mentioned in Article 309. 10. Acts and actions referred to in Articles 21, 26, 27, 28, 29, 30, 32, 34, and 35. The parents of the female seduced, abducted, raped, or abused, referred to in Number 3 of this article, may also recover moral damages. The spouse, descendants, ascendants, and brothers and sisters may bring the action mentioned in Number 9 of this article, in the order named. Willful injury to property may be a legal ground for awarding moral damages if the court should find that, under the circumstances, such damages are justly due. The same rule applies to breaches of contract where the defendant acted fraudulently and in bad faith. Art. 2208. In the absence of stipulation, attorneys' fees and expenses of litigation, other than judicial costs, cannot be recovered, except 1. When exemplary damages are awarded. 2. When the defendant's act or omission has compelled the plaintiff to litigate with third persons or to incur expenses to protect his interest. 3. In criminal cases of malicious prosecution against the plaintiff. 4. In case of a clearly unfounded civil action or proceeding against the plaintiff. 5. Where the defendant acted in gross and evident bad faith in refusing to satisfy the plaintiff's plainly valid, just and demandable claim. 6. In action for legal support. 7. In actions for the recovery of wages of household helpers, laborers and skilled workers. 8. In actions for indemnity under workmen's compensation and employers' liability laws. 9. In a separate civil action to recover civil liability arising from a crime. 10. When at least double judicial costs are awarded. 11. In any other case where the court deems it just and equitable that attorney's fees and expenses of litigation should be recovered. In all cases, the attorney's fees and expenses of litigation must be reasonable. There was no voluntary submission to the jurisdiction of the RTC on the part of respondents' SPs. Sci. et al. As a general rule, one who seeks an affirmative relief is deemed to have submitted to the jurisdiction of the court. Thus, it has been held that the filing of motions to admit answer, for additional time to file answer, for reconsideration of a default judgment, and to lift order of default with motion for reconsideration is considered voluntary submission to the trial court's jurisdiction. As a general rule, one who seeks an affirmative relief is deemed to have submitted to the jurisdiction of the court. Thus, it has been held that the filing of motions to admit answer, for additional time to file answer, for reconsideration of a default judgment, and to lift order of default with motion for reconsideration is considered voluntary submission to the trial court's jurisdiction. The service of summons undertaken in the instant case is undoubtedly defective. In the absence of service of summons or when the service of summons upon the person of the defendant is defective, the court acquires no jurisdiction over his person, and the proceedings in any judgment rendered are null and void. It must be stressed that the fact that service of summons was defective in the instant case is undisputed. Statutory rape case. I don't even know her is the usual excuse of a rapist who expects a reprieve from conviction, as if knowing the victim is a precondition to carnal desire. And while abhorrent in all instances, lust manifested through rape is especially reprehensible when committed against a child. Thus, our law on statutory rape demands only the requisite proof of the victim's age and of carnal knowledge with the accused to sustain his conviction. In People v. Arpin, 15, citing People v. McAfee, 16, the court explained that consent is immaterial, and force and intimidation are not necessary in every prosecution for statutory rape viz. Rape under paragraph 3 of Article 335 is termed statutory rape as it departs from the usual modes of committing rape. What the law punishes in statutory rape is carnal knowledge of a woman below 12 years old. Hence, force and intimidation are immaterial, the only subject of inquiry is the age of the woman and whether carnal knowledge took place. The law presumes that the victim does not and cannot have a will of her own on account of her tender years. The child's consent is immaterial because of her presumed incapacity to discern evil from good. 17. Emphasis in the original and underlining supplied. This court has held time and again that testimonies of rape victims who are young and immature deserve full credence, considering that no young woman, especially of tender age, would concoct a story of defloration, allow an examination of her private parts, and thereafter pervert herself by being subject to a public trial. if she was not motivated solely by the desire to obtain justice for the wrong committed against her. Euthymatory TV are generally badges of truth. It is highly improbable that a girl of tender years, one not yet exposed to the ways of the world, would impute to any man a crime so serious as rape if what she claims is not true. Art 2234. While the amount of the exemplary damages need not be proved, the plaintiff must show that he is entitled to moral, temporary or compensatory damages before the court may consider the question of whether or not exemplary damages should be awarded. In case liquidated damages have been agreed upon, although no proof of loss is necessary in order that such liquidated damages may be recovered, nevertheless, before the court may consider the question of granting exemplary in addition to the liquidated damages, the plaintiff must show that he would be entitled to moral, temporary or compensatory damages were it not for the stipulation for liquidated damages. In Astores v. Supingen, GR number 175139, the 18th of April 2012, 670 SCRA 95, 105-106, this court enunciated that forbearance of money, goods or credits XXX refer to arrangements other than loan agreements where a person acquiesces to the temporary use of his money, goods or credits pending happening of certain events or fulfillment of certain conditions. Item 2.2 of our pronouncement in Eastern Shipping Lines v. CA, GR number 97412, the 12th of July 1994, 234 SCRA 78, 95-97, provides. 2. With regard particularly to an award of interest in the concept of actual and compensatory damages, the rate of interest, as well as the accrual thereof, is imposed, as follows. XXXX2. When an obligation, not constituting a loan or forbearance of money, is breached, an interest on the amount of damages awarded may be imposed at the discretion of the court at the rate of 6% per annum. No interest, however, shall be adjudged on unliquidated claims or damages except when or until the demand can be established with reasonable certainty. Accordingly, where the demand is established with reasonable certainty, the interest shall begin to run from the time the claim is made judicially or extrajudicially. Art. 1169, Civil Code, but when such certainty cannot be so reasonably established at the time the demand is made, the interest shall begin to run only from the date of the judgment of the court is made, at which time the quantification of damages may be deemed to have been reasonably ascertained. The actual base for the computation of legal interest shall, in any case, be on the amount finally adjudged. To recapitulate and for future guidance, the guidelines laid down in the case of Eastern Shipping Lines are accordingly modified to embody BSPMB Circular number 799, as follows. When an obligation, regardless of its source, i.e., law, contracts, quasi-contracts, delicts or quasi-delicts is breached, the contravenor can be held liable for damages. The provisions under Title 18 on damages of the Civil Code govern in determining the measure of recoverable damages. 2. With regard particularly to an award of interest in the concept of actual and compensatory damages, the rate of interest, as well as the accrual thereof, is imposed, as follows. 1. When the obligation is breached, and it consists in the payment of a sum of money, i.e., a loan or forbearance of money, the interest due should be that which may have been stipulated in writing. Furthermore, the interest due shall itself earn legal interest from the time it is judicially demanded. In the absence of stipulation, the rate of interest shall be 6% per annum to be computed from default, i.e., from judicial or extrajudicial demand under and subject to the provisions of Article 1169 of the Civil Code. 2. When an obligation, not constituting a loan or forbearance of money, is breached, an interest on the amount of damages awarded may be imposed at the discretion of the court at the rate of 6% per annum. No interest, however, shall be adjudged on unliquidated claims or damages, except when or until the demand can be established with reasonable certainty. Accordingly, where the demand is established with reasonable certainty, the interest shall begin to run from the time the claim is made judicially or extrajudicially. Art. 1169, Civil Code, but when such certainty cannot be so reasonably established at the time the demand is made, the interest shall begin to run only from the date the judgment of the court is made, at which time the quantification of damages may be deemed to have been reasonably ascertained. The actual base for the computation of legal interest shall, in any case, be on the amount finally adjudged. 3. When the judgment of the court awarding a sum of money becomes final and executory, the rate of legal interest, whether the case falls under paragraph 1 or paragraph 2, above, shall be 6% per annum from such finality until its satisfaction, this interim period being deemed to be by then an equivalent to a forbearance of credit. ID. at 457-458. Sufficient provocation. The circumstances that transpired immediately before and after the stabbing negate evident premeditation. The time when accused appellant conceived the crime cannot be determined. Even assuming that there was an altercation that arose between the accused appellant and the victim due to the remarks made by the former to the latter, this is not the overt act indicative of his criminal intent. Simply put, the prosecution failed to establish that there was a sufficient lapse of time for accused appellant to reflect on his decision to kill the victim and the actual execution thereof. The court, however, agrees with the CA in appreciating the mitigating circumstance of illness as would diminish the exercise of willpower of appellant without, however, depriving him of the consciousness of his acts pursuant to Article 13, paragraphs 9 and 10 of the RPC. As he was found by his examining doctors to have diminished capacity to discern what was wrong or right at the time of the commission of the crime. For sufficient provocation under Article 13, paragraph 4 of the Revised Penal Code of the Philippines to apply, 3 requisites must be present. A provocation must be sufficient. B. It must be immediate to the commission of the crime, and C. It must originate from the offended party. Sufficient, according to jurisprudence, means adequate to excite a person to commit the crime and must accordingly be proportionate to its gravity. In Bautista v. Court of Appeals Gr. No. L. 46025, September 2, 1992, the mitigating circumstance did not apply since it is not enough that the provocating act be unreasonable or annoying. Certainly, calling a person gay as in this case is not the sufficient provocation contemplated by law that would lessen the liability of the accused. Immediate, on the other hand, means that there is no interval of time between the provocation and the commission of the crime. Hence, in one case, People v. Co. 67 Aug. 7451, the Supreme Court ruled that provocation occurring more than 1 hour before the stabbing incident is not immediate, and in People v. Benito 62 SCRA 351, 24 hours before the commission of the crime. Per admission of the defense witnesses, the taunting done by the victim occurred days before the stabbing incident, hence the immediacy required by law was absent. The lapse of time would have given the accused chance to contemplate and to recover his serenity enough to refrain from pushing through with his evil plan. The Revised Penal Code in Article 12(1) provides Art. 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. 1. An imbecile or an insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony, delito, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. An insane person is exempt from criminal liability unless he has acted during a lucid interval. If the court therefore finds the accused insane when the alleged crime was committed, he shall be acquitted, but the court shall order his confinement in a hospital or asylum for treatment until he may be released without danger. An acquittal of the accused does not result in his outright release, but rather in a verdict which is followed by commitment of the accused to a mental institution. In the eyes of law, insanity exists when there is a complete deprivation of intelligence in committing the act. Mere abnormality of the mental faculties will not exclude imputability. The accused must be so insane as to be incapable of entertaining a criminal intent. He must be deprived of reason and act without the least discernment, because there is a complete absence of the power to discern or a total deprivation of freedom of the will. Since the presumption is always in favor of sanity, he who invokes insanity as an exempting circumstance must prove it by clear and positive evidence. And the evidence on this point must refer to the time preceding the act under prosecution or to the very moment of its execution. To ascertain a person's mental condition at the time of the act, it is permissible to receive evidence of the condition of his mind within a reasonable period both before and after the time. Direct testimony is not required. Neither are specific acts of derangement essential to establish insanity as a defense. Circumstantial evidence, if clear and convincing, suffices, for the unfathomable mind can only be known by overt acts. A person's thoughts, motives, and emotions may be evaluated only by outward acts to determine whether these conform to the practice of people of sound mind. Non-forum shopping. Rule 7, Section 5 of the Rules of Court prescribes the rule on certificates of non-forum shopping. To wit, Section 5. Certification against forum shopping. XXX. Failure to comply with the foregoing requirements shall not be curable by mere amendment or the complaint or other initiatory pleading, but shall be cause for the dismissal of the case without prejudice, unless otherwise provided, upon motion and after hearing. The submission of a false certification or non-compliance with any of the undertakings therein shall constitute in direct contempt of court. without prejudice to the corresponding administrative and criminal actions. If the acts of the party or his counsel clearly constitute willful and deliberate forum shopping, the same shall be ground for summary dismissal with prejudice and shall constitute direct contempt, as well as a cause for administrative sanctions. Emphasis applied. A violation of the above-mentioned rule other than through willful and deliberate forum shopping does not authorize the RTC to dismiss a case without motion and hearing. Even the submission of a false certification of non-forum shopping does not automatically warrant dismissal of the case, even if it might constitute contempt of court. Significantly, the petitioner did not move for the dismissal of the petition in civil case number 2257 or to cite the respondents for indirect contempt. She also failed to show that the respondents committed willful and deliberate forum shopping. Instead, she raised the issue of forum shopping and non-compliance with Rule 7, Section 5 only on appeal. This court is mindful of the rule that trial courts may dismiss a case motu proprio on the ground of litis pendentio, among other things. This rule is found in Rule 9, Section 1 of the Rules of Court. Section 1. Defenses and objections not pleaded. Defenses and objections not pleaded either in a motion to dismiss or in the answer are deemed waived. However, when it appears from the pleadings or the evidence on record that the court has no jurisdiction over the subject matter, that there is another pending action between the same parties for the same cause, or that the action is barred by a prior judgment or by statute of limitations, the court shall dismiss the claim. Emphasis applied. However, the ground for dismissal must be evident from the pleadings or from the evidence on record before a court can dismiss a case motu proprio. The legitimacy of the child. The legitimacy of the child cannot be contested by way of defense or is a collateral issue in another action for a different purpose. The necessity of an independent action directly impugning the legitimacy is more clearly expressed in the Mexican Code, Article 335, which provides, the contest of the legitimacy of a child by the husband or his heirs must be made by proper complaint before the competent court. Any contest made in any other way is void. This principle applies under our Family Code. Articles 170 and 171 of the Code confirm this view, because they refer to the action to impugn the legitimacy. This action can be brought only by the husband or his heirs and within the periods fixed in the present articles. Upon the expiration of the periods provided in Article 170, the action to impugn the legitimacy of a child can no longer be brought. The status conferred by the presumption, therefore, becomes fixed, and can no longer be questioned. The obvious intention of the law is to prevent the status of a child born in wedlock from being in a state of uncertainty for a long time. It also aims to force early action to settle any doubt as to the paternity of such child, so that the evidence material to the matter, which must necessarily be facts occurring during the period of the conception of the child, may still be easily available. Only the husband can contest the legitimacy of a child born to his wife. He is the one directly confronted with the scandal and ridicule which the infidelity of his wife produces, and he should decide whether to conceal that infidelity or expose it, in view of the moral and economic interest involved. It is only in exceptional cases that his heirs are allowed to contest such legitimacy. Outside of these cases, none, even his heirs, can impugn legitimacy. That would amount to an insult to his memory. Article 263 refers to an action to impugn the legitimacy of a child, to assert and prove that a person is not a man's child by his wife. However, the present case is not one impugning petitioner's legitimacy. Respondents are asserting not merely that petitioner is not a legitimate child of Jose, but that she is not a child of Jose at all. XXX. The mere registration of a child in his or her birth certificate as the child of the supposed parents is not a valid adoption. Does not confer upon the child the status of an adopted child and the legal rights of such child, and even amounts to simulation of the child's birth or falsification of his or her birth certificate, which is a public document. The presumption of legitimacy. The presumption of legitimacy in the Family Code XXX actually fixes a civil status for the child born in wedlock, and that civil status cannot be attacked collaterally. The legitimacy of the child can be impugned only in a direct action brought for that purpose by the proper parties, and within the period limited by law. The legitimacy of the child cannot be contested by way of defense or is a collateral issue in another action for a different purpose. The necessity of an independent action directly impugning the legitimacy is more clearly expressed in the Mexican Code, Article 335, which provides, the contest of the legitimacy of a child by the husband or his heirs must be made by proper complaint before the competent court. Any contest made in any other way is void. This principle applies under our Family Code. Articles 170 and 171 of the Code confirm this view, because they refer to the action to impugn the legitimacy. This action can be brought only by the husband or his heirs and within the periods fixed in the present articles. Upon the expiration of the periods provided in Article 170, the action to impugn the legitimacy of a child can no longer be brought. The status conferred by the presumption, therefore, becomes fixed, and can no longer be questioned. The obvious intention of the law is to prevent the status of a child born in wedlock from being in a state of uncertainty for a long time. It also aims to force early action to settle any doubt as to the paternity of such child, so that the evidence material to the matter, which must necessarily be facts occurring during the period of the conception of the child, may still be easily available.